Good evening, everybody, and welcome to our webinar. I'm Amy Stroud, and this is Paul Fuller. And this evening, we're going to be talking about how to deal with errant personal representatives. We've divided the talk roughly into two halves. I will be looking at some of the perhaps less contentious and initial stages that interested parties in an estate can take where they have problems with the management of the estate and they want to look at procedures that might be perhaps more low-key but might solve these difficulties. Paul is going to talk to you then about some of the more draconian measures that might be needed if those problems aren't solved or if perhaps a more significant or problematic breakdown is evident. If I can alert you firstly to our disclaimer, because this seminar is of course just an oversight, and if you want full legal advice, please don't rely upon it. Also, we have our profiles, which you can look at. Obviously, these slides will be available on the website after the webinar. So without more ado, I'm going to start and look at as I said, these early measures, softer measures that can be extremely useful. And I talk about this partly because my experience often of these sorts of cases have been of often not particularly big value estates and often family disputes where the PR is not a professional, not a firm of solicitors, but a member of the family. There's acrimony between siblings, or there are vengeful stepchildren. There's a lot of emotional baggage, a lot of history of disagreement in the family. And in fact, it's the worst possible situation in which to drop the sudden present of a will that people aren't happy with, or problems in administering an estate where there are difficulties over how that estate should be dealt with. And often there are solutions that where applications can be made that are not as expensive as all that, but can sort these processes out. Just a quick reminder, firstly, of the beneficiaries' rights. So beneficiaries to an estate don't have any rights in the property until they are vested in that beneficiary. So the PR, the personal representative, has until that vesting both the legal and the equitable ownership of the property, and all the beneficiary has is what we call a shows in action. So if you like, a bundle of personal rights which could be enforced in court proceedings. We also need to remind ourselves, of course, of the PR's statutory duty of care. Before the PR obtains the grant of probate or letters of administration, the PR has no particular duty at all, in fact, to the deceased estate, the beneficiaries, or any creditors. But once they've taken the grant, they are bound by the same duty of care as you find in the Trustee Act, under Section 35 of the Trustee Act. And you can see I've set that out in the slide, the standard duty of care, and of course, the regard to any particular special knowledge or experience that the PR has. And of course, if the PR is acting in the course of their professional duties, then that standard is higher still. It's also worth looking at Schedule 1 of the Trustee Act, because of course that sets out trustees' powers, although PR's powers are often well in excess of that schedule. What other considerations do we need to bear in mind when we're looking at PR's duties? It's owed, of course, to creditors as well as beneficiaries. Alarmingly, PR remains a PR for the rest of their life, unless, of course, the grant's limited or revoked or they're removed from office. And that's even after the administration of the estate is finalised. It probably falls outside the remit of this talk to a degree, but it's worth bearing in mind this dividing line between PRs and trustees, because of course, if there are interests in the estate that actually extend beyond the PR's duties of collecting assets, paying creditors, and distributing the estate. But for example, if parts need to be held on trust for minor beneficiaries or for potential sale, then upon the conclusion of the administration, the PR essentially could become a trustee, and you can have both a PR and trusteeship in tandem. That's also possible. The duties, the general duties, as I said, of the PR do not extend beyond, as I said, collection of assets and administration of the estate. And it's set up quite pithily at section 25 of the Administration of Estates Act. Here we see the three main requirements there: collect and get in real and personal estate, be prepared if required to do so to provide a full inventory and render an account, and deliver up grant of probate to the High Court if required to do that. The section 25 is also the first material point, I think, for those interested parties or beneficiaries who have concerns about an aspect of the management of the estate. So under section 25, anyone with an interest, and that includes a potential interest or what we call a contingent interest, being an interest that's conditional upon some qualification, anyone can make an application for an inventory and account under section 25. And in fact, the PR should be keeping estate accounts in any event and making them available at the request of any creditor or beneficiary. But if they're not, or if the accounts they provide are simply not clear, then a section 25 application may be necessary. And it can also be made against former PRs. So, for example, if you have a new PR who has taken their place and they need to understand some aspect of the accounts that aren't clear, they can likewise make that application. There's also a recent case from last year, Howes and Howes, in the High Court, where an estate was the beneficiary of another estate, but they shared the personal representative, and so a section 25 application was made on behalf of that estate. What's the procedure for obtaining an account under section 25? You can see the non-contentious probate rules set it out in detail. It has to be made by way of summons, using supported by a witness statement or an affidavit, accompanied by a statement of truth which sets out the details of the estate, the nature and extent of the applicant's interest, and the reasons why an inventory and account is sought. The court can prescribe the information that's included in that inventory and account, but of course you need to remember that if you have an asset such as a business which has continued to accrue profits after the date of death, then you wouldn't include those. The value of the assets is taken at the date of death. And the court will, under the section 25 process, sign off the accounts if it's satisfied them with them, which prevents any further challenges. I must point out, I think there is an error on the slide, and it shouldn't be CPR 8. So by way of summons with supporting witness statement or affidavit, I've just noticed that. The standard for the accounts is also one that's not always immediately apparent to interested applicants. For the inventory itself, you can often rely on the IHT 400 form, or the inheritance tax account form, that's submitted by the PR to HMRC in order to obtain the grant of probate, and that will often be regarded as sufficient. But in terms of what accounts you produce, because of course if you're dealing with small family estates, you may have seen all manner of types of accounts, and some on the back of a receipt, or and in fact what's always a useful guide is the Law Society Wills and Inheritance Quality Scheme Protocol, which sets out a guide for what ideally should be in the set of accounts, and you'll see those set out on the slide there. There are limitations to any section 25 application. There isn't much the court can do if the PR is uncooperative, or if it appears that the inventory and account is false in some way. So the court's powers are limited really. It can make a costs order. I think it could make some sort of declaratory relief if it's here's further evidence for the applicant. Probably most significantly is if the PR doesn't produce an inventory and accounts, then that will be taken as an admission of assets. So in other words, the PR has the assets in his hands. But inevitably, the applicant would have to take their issue to another forum, essentially. And what about costs as well? These are usually borne by the estate, but there are some exceptions. I've seen a slew of 19th century cases where there were quite extraordinary time lapses before the application was made. We're talking about sort of 18 to 45 years sometimes. And of course, in those situations, you can imagine that the applicant might have to bear their own costs. And there will also be situations where the PR has acted in such a way as to exacerbate the costs. So retention of estate documents, or there's been an underlying problem with the administration which has led to the application, the PR may be responsible for those costs. So what is the other route? Well, CPR 64.2, which you're probably very familiar with, which is a very open-ended, broad base offering assistance for parties unhappy with some aspect of management of an estate or trust. And here we see that the section applies to claims for the court to determine any question arising in the administration of the estate of a deceased person or the execution of a trust. In fact, if you can hone in on this particular aspect, 64.2a, it's expanded under Practice Direction 64A, which offers 3 particular remedies. And if I focus on the first one, to provide and, if necessary, verify accounts, there you see the basis on which an application of the Rule 64 can be made. The procedure claims this time come under Part 8, and they should be accompanied by a supporting witness statement. They're issued in the Chancery Division in the Property Trust and Probate List. It's useful to look at Practice Direction 57AA, which sets out the full detail of the Business and Property List. And in general, all PRs should be joined as parties. And in fact, any other person with an interest in the estate may well need to be joined as a party, but there may be occasions when there's not really, there are types of beneficiary where no consequence really flows to them and they don't need to be. If you have a number or multiple beneficiaries who all have a common interest, you may find it expedient to use CPR 19.72D2, and whereby you arrange for one beneficiary to represent the rest. And I would also highlight Part 64.3, which recommends using the practice direction for pre-action conduct and protocols. So what happens in a 64 Rule 64 hearing? The application is usually heard by a master or sometimes a judge, and the court's likely to adjourn the proceedings, which will enable the PRs to produce accounts, essentially. And then when they come back, the claimant is often granted, or maybe, if appropriate, granted consequential relief of some sort, which might amount to payments of sums due, perhaps a reconstitution of the estate. There are 2 types of accounts, what's called common account and account on the footing of willful default. The common account is less punitive, and it's, I suppose you could say, it's when a PR hasn't been as bad as all that. And essentially the fault is, the default for the PR is that they simply failed to account for the assets in the estate. Practice Direction 40A is a helpful guide to the detail of this procedure. But in essence, the PR will provide accounts and supporting documents, and the claimant will prepare a written schedule where each point in dispute, contested point, is set out, and the court will simply go through them and make findings. The burden is on the PR to show that any payments, or if you like, discharges out of the state were legitimately made. And they'll be legitimate if, for example, a payment to a creditor or beneficiary, which is due, of sums due to them, would be a legitimate payment, or the cost of administration, including the cost of producing the account, would be legitimate, or any property lost by the PR, which is not due to the fault of the PR, would be a legitimate a discharge. What won't be is if it is incurred by the fault of the PR, or, for example, the administrative cost, which was unreasonable and was down to the fault of the PR, that those would be struck out by the court. And the burden is on the claimant to show what sums are part of the estate. I'm going to hasten on to footing of willful default, because this is a more rigorous regime, but it's restricted to where the PR has deliberately, willfully and intentionally acted in breach. And generally, if you look, I've set out the test in Reed Tebbs, will probably arise where there's been at least 2 instances, possibly more, because essentially, as you can see, that the thrust of Tebbs is that the past conduct is such that there's a real belief, fear that more is going to happen of that same sort. So how do you know which to go for? You have to look at, there's a sliding scale essentially. What are the reasons for the default? Are the defaults really admitted? What are all the circumstances? Is there grounds for further suspicion? There's quite a case of 2019, Cadogan and Cadogan, which concerned sibling co-administrators managing the properties of their deceased mother. And the court, interestingly, finds it appropriate to apply common account to the claimant co-administrator, but account on the footing of willful default to her brother. And so you see there a comparison of the two systems within the same case. As I said, willful default's more rigorous, not ordered unless there's really robust evidence. And it would take the same form as a common account, but the PR may have to account for and actually repay sums that have been lost. And the court has greater powers to investigate and unearth misconduct. Where the PR admits that he has his hands on assets that are due to the beneficiary or creditor, the court won't order an account, will instead order payment. And that would be the case regardless of whether there are sufficient assets to make that payment or not. Of course, when you look at this aspect of the law, you have to bear in mind the intervention of CPR 14, which governs the need for admissions to be in writing, and that they need to be express and clear. And in the old days, they didn't necessarily need to be in writing, they could even be inferred, but that's no longer the case. And admissions can also be withdrawn. Looking at the time, I'm not going to go into there's quite a lot of recent case law on issue of withdrawal of admissions. The factors the court considers are in Practice Direction 14.7 and would include matters such as the grounds of the application to withdraw, the conduct of the parties, the stage the proceedings have reached, the interest of the administration of justice. And it's certainly become harder to withdraw admissions since 2013 because of the revision to the overriding objective. But again, I don't want to go into the detail of that given the time we have. Very quickly, because again, these are rare, so they're not certainly not run of the mill. Administration orders, you'll see at 64.2b, the court can make an administration order whereby the court simply takes over the running of the administration of the estate or running of the trust. They're extremely rare now because and courts much prefer the sort of honing in on specific issues that 64.2a and Practice Direction 64a provide. You might get an administration order, for example, where an estate is insolvent, or perhaps if there's a barrage of hostile claims which have been overwhelmed, where the administrators have become overwhelmed by. But in fact, you might be more likely, and Paul may deal with this to an extent as well, and to pursue the avenue of a judicial trustee, which is a mechanism whereby a trustee can be appointed alongside the existing PR, which is certainly probably a more cost-effective option, doesn't incur the huge administrative burdens that an administration order would if the court were to do that. Another also perhaps less usual measure these days is payments into court. If you look at Practice Direction 64a, 2a, 2, pay into court money which he holds in that capacity. This is where, again, not a popular choice with courts because of the cost and the administrative burden, but there might be an order for the PR to pay monies into the court where there's an admission of funds in the PR's hands. The PR actually has the funds in their hands. There are reasonable grounds to believe the funds are at risk. So, for example, read Braithwaite, a case from 1882, or there's no other feasible way to safeguard the funds. So the order can only be made if the money is actually in the PR's hands, and that's quite old authority, Nutter and Holland. But again, it doesn't seem to have actually changed this principle since the CPR came into being, and it still seems to be applicable. That if you look at Practice Direction 64A.12A2, the PR must pay into court money which he holds in that capacity, referencing the need to have it in his hands. And there, as I said, there are very few reported cases of this. So it's not something that one comes across very often. You would use the Part 8 procedure if you were following that avenue, and there's no specific time to apply, but it should be a reasonable one. Finally, it's probably worth looking very briefly at the obligations that trustees or PRs have towards beneficiaries in terms of production of documents or disclosure or other duties regarding information. Generally, the case that you may very well be familiar with in terms of trustees' obligations in that regard, Schmidt and Rosewood Trust Limited, generally applies to PRs too. And you see the core principles set out there. Beneficiaries are not entitled to disclosure as of right, which of course changed following Schmidt. Previously, there had been what was regarded as a proprietary right to documents, but they may have a legitimate expectation of it. And the right to information by beneficiaries is founded on the trustee's fiduciary duty to provide accounts and keep beneficiaries informed. So a beneficiary will need to prove that his prospect of benefiting under the trust is enough to justify the disclosure of that information. And also, the legal position prior to Rosewood may still be relevant because, of course, what we're left with is a situation where trustees have a discretion. Even though there's no de facto entitlement by beneficiaries, the trustees have a discretion and they have to exercise it properly. They have to take into account the purpose of the request, and they have to take into account what's in the best interests of the beneficiaries as a whole. And while trustees shouldn't feel compelled to give reasons for their decision in relation to the dispositive function of their duties, which is what we call the Londonderry principle, this was held in the case of Lewis and Tamplin a few years ago. This doesn't extend to their administrative functions. They may need to justify their administrative actions to the beneficiaries. You'll see in my slides I've set out brief lists of what documents are likely to be disclosable by a PR, but also what are likely to not be disclosable there, which you can consider in more detail. And of course, there are also documents which perhaps don't easily fit into categories, such as legal advice or set laws and letter of wishes. And these will depend very much on the individual circumstances because there tend to be authorities going both ways. Considerations such as privilege or, for example, a set law's request for confidentiality are not the ultimate arbiter of whether a document is disclosable or not. There is also an interesting recent case where Dawson Damer against Taylor Wessing, where trustees administering an estate sought to resist an application for disclosure unsuccessfully. Or in the end, it wasn't, because it turned out the trust was governed by the law of the Bahamas. But the Court of Appeal, Lady Justice Arden, did conclude that actually it should be disclosed to the beneficiaries. So again, it is important that the discretion is exercised properly by a PR. And there are reasons why trustees might want to refuse disclosure. Confidentiality, for example, if there's confidentiality as between beneficiaries, or perhaps it's impractical to do so, or there's commercially sensitive information, or it's too expensive, or it's requested by a beneficiary for an improper purpose, for example, a purpose that's not in the interests of the beneficiaries as a whole. One example might be if one beneficiary was challenging the validity of the trust. But of course, there are also halfway houses for PRs, for example, redacting documents or requesting undertakings, offering to show documents to the advisor of a beneficiary, for example, but not the beneficiary, him or herself. And don't forget that if there isn't a good reason for the PR to disclose, that it could make them liable for costs. But obviously, if the beneficiary is of the view that that's occurred, she might need to make an application under CPR 64. I've dealt, just in the last 5 minutes or so, you'll see I've put in 3 minor sections of the Trustees Act in relation to rectifying PR mistakes and distribution, which is also worth looking at. But I think I'm beginning to trespass on Paul's time now. So without more ado, I'm going to hand over to Paul, and he will tell you about some of the other measures that can be employed if those don't work.
Thank you, Amy. Well, yes, hello, Paul Fuller. As Amy mentions, I'd like to have a look at now some other options that are available to interested parties who are dissatisfied perhaps with the way in which the estate is being administered, or as the case very well may be, the estate's not being administered, but perhaps some of those options that Amy has run through in great detail are either not really appropriate. For example, there may be a situation where the executors or the persons who are first in line to apply for a grant of administration haven't applied for a grant, or where those people cannot be found, or where perhaps there's a lack of capacity, or where there has been a grant, but there's dissatisfaction with the way in which the estate's being administered, and perhaps our clients have run through and perhaps even exhausted those options that Amy has run through today to no avail. What can be done then? Well, our clients might then arrive at the conclusion that it's just not appropriate for the personal representatives to continue in their role. So what's to be done then? Well, probably the first consideration is, as I touched on, whether or not there's been a grant yet. And if there hasn't been a grant, then the citation process is certainly probably the first thing that's worth considering. The advantage, I think, of the citation process is it's really rather straightforward. It's essentially a procedural mechanism, and therefore it can be quite quick and quite a cost-effective measure. It's essentially the citation process is issued under Rule 46 of the non-contentious probate rules, and it can be issued by executors or where named executors with a priority have not intermingled with the estate, where they failed to take a grant, but they refused to renounce their right to a grant, or where they have intermingled with the estate, but 6 months after the death, they've still not taken a grant. Now, before issuing the citation, the applicant has to first lodge a caveat with the probate registry, and that will essentially prevent the grant until the issue has been resolved finally by the court. But once a caveat's been lodged with the probate registry, the citation then needs to be issued with the probate registry. It's settled by a district judge or registrar, and has to be supported by an affidavit sworn by the person who's issuing the citation. Then has to be personally served on the person who's being cited, unless the court orders otherwise. And then the person who's served with the citation, the citee, then has 8 days to enter an appearance. Now, if that person, and of course there's a very short time frame, which is why this can be quite a useful tool, doesn't enter an appearance within that 8-day period, then if they've not intermeddled with the estate, then their executive essentially ceases by operation of law, and the administration of the estate dissolves as if that person was never appointed. If they have intermeddled with the estate, then the citer can apply to the court for an order that either they or someone else who's specified in the summons is appointed as the new or a new personal representative. Now, an important consideration here, though, is that if the person cited does enter an appearance within the 8-day time limit, then pursuant to Rule 47(4) of the non-contentious probate rules, all they then need to do is make an application, which is made ex parte without notice, to the court for a grant in their favour. And so it could be the case that the first that our clients learn about that is when they're notified that the person who is cited has then been appointed as a personal representative to the estate. And so if our client's objective is to avoid that person's appointment, then in those situations, a citation may not be the best way to go. And in that case, again, we're talking about situations here where there hasn't yet been a grant. An alternative that is worth considering is an application pursuant to Section 116 of the Senior Courts Act. And that section empowers the court to pass over, is the term used, a personal representative before the grant is obtained. And the court then can pass over in favour of some other person where the court considers that there are special circumstances, it says within the section, that render making an order passing over that person, quote, necessary or expedient. So you can see that essentially gives the court quite a broad discretion to pass over. The application needs to be made to the probate registry and again supported by an affidavit. And what's useful as well about the Section 116 process is that any interested party can apply for an order passing over a personal representative pursuant to that section. So crucially, that's not just beneficiaries, but other interested parties, including, for example, someone who says they have a claim under the 1975 Inheritance Act. So that's all very well and good. But what about situations where there's been a grant already? Well, in those circumstances, we can give consideration to an application under Section 50 of the Administration of Justice Act. And that section empowers the court to terminate personal representatives' appointment and indeed appoint new personal representatives in their place. Unlike an application under Section 116, only beneficiaries are able to make applications under Section 50. An application should be made again to the Business and Property Division of the High Court using the Part 8 claim procedure, and specifically following the rules set out in Part 57 of the Civil Procedure Rules, specifically Part 57(12) through 14. Most important to note there probably is that all personal representatives, whether it's those that you're looking to remove or not, need to be joined to the proceedings. Now, because the personal representative derives their title from the will, the court can exercise the power under Section 50 against named executors, whether or not there's been a grant. As to intestate estates, though, the administrators derive their power from the grant, and so in those cases the court can't exercise its discretion until there's been a grant. And so if you're dealing with an intestate estate and there hasn't been a grant, then you're probably going to have to go back and consider either the citation process or an application under Section 116. What are the sorts of grounds that we tend to see founding applications to remove and appoint new personal representatives? Well, there isn't really an exhaustive list, but some of the bases that we tend to see are, as we've already heard, a failure by the personal representatives to expeditiously and properly administer the estate. There may be allegations that the personal representatives are conflicted, and of course there may be allegations that they're not fit for office, including where the personal representative perhaps lacks mental capacity. There's a case here, 2010 case, which is quite useful. Richard Snowden QC, who was sitting as judge in the case of Angus and Emmett, noted that the court's power to appoint and or terminate personal representatives, appointment and appointee personal representatives under Section 50 isn't limited to where there's misconduct or maladministration of the estate. But what there does need to be is genuine risk or actual detrimental impact to the administration of the estate. And citing Williams and Mortimer, 19th edition, the judge noted that if the administration has come to a standstill, all relations between the representatives and the beneficiaries have broken down, the court will ordinarily remove the personal representatives and appoint a new one to enable the administration to be completed. It's not necessary to establish wrongdoing if it's become impossible or difficult for the administration to be completed. Then the order for the personal representatives removal will usually be made. So you can see there the real thrust of the court's discretion in these applications is the extent to which whatever the basis of the application gives rise to a finding that the estate can no longer be administered properly. A quick note on conflicts of interest. This is a very recent case, the estate of MacDonald, 2022, which I came across, which I found quite interesting. Where there is a conflict of interest, it appears following MacDonald that the court won't exercise its discretion and remove and appoint new personal representatives where the personal representative has a conflict of interest. And that conflict of interest arises as a result of the testator's own wishes. So in MacDonald, the testator made the executor a beneficiary of a lifetime trust in the estate. The executor then wished to pursue a claim against the estate in his capacity as a beneficiary. Of course, he was unable to do so because he was conflicted, and so he applied pursuant to Section 50 for the termination of his appointment. And the court held that because the conflict or potential conflicts arose as a result of the testator's wishes, i.e. that he should be both an executor and a beneficiary, that the court respected those wishes and was not prepared to remove him as a personal representative on that basis. In MacDonald, there were other grounds, and the court did order removal of the personal representative. So essentially, he got what he was looking for. But what that tells us is if there is a conflict of interest that arises as a result of the testator's own wishes, then it's unlikely that the court would order the removal of the personal representative in those circumstances. That takes me on to the approach that the courts adopt when deciding whether to exercise their discretion to terminate personal representatives' appointments. Essentially, there's three guiding principles here. Firstly, the beneficiaries will always be the primary consideration, and that feeds into what we were discussing before. The main consideration really is whether the estate can be properly administered. And a real threat of detriment to the administration of the estate will be usually good grounds for the court to make an order. But as we heard just now discussing the case of MacDonald, the court will always also take into consideration the testator's wishes, and there's a couple of authorities there for you. So whenever considering an application, whether it's a citation or Section 116 or 50 application, do bear in mind the considerations that the court will have when deciding whether or not to exercise its discretion, and meet those considerations, I would suggest, head on in your evidence. And if you take the view after considering matters that it's unlikely on the basis of the evidence that you're likely to succeed in an application, then it may well be worth considering other options. And Amy discussed and touched very briefly, and I'll touch even more briefly on the option of perhaps an application to appoint a judicial trustee in situations where perhaps the estate isn't being administered in quite the way you'd like, perhaps things are a bit slow, but you take the view that it's unlikely that a Section 50 application would succeed, then it may well be worth considering applying for the appointment of an additional judicial trustee who can hurry things along and assist with other matters. So just to sum up then, this is just a few bullets of points that you would want to consider if you were looking at the more draconian option of removing the personal representatives. First, always consider whether there's been a grant. If there hasn't, then the citation process is potentially a quick and cost-effective means of bypassing those who would usually take a grant in favour of your client or someone else. But there could be undesired consequences. Those people who have dragged their feet thus far could end up being appointed and then continue to drag their feet. Alternatively, then consider the passing over process, which the court has power to do pursuant to section 116 of the Senior Courts Act. If there's been a grant, then consider section 50 applications. Always consider your grounds: maladministration, is there hostility, conflict of interest, lack of capacity, but even more importantly, always consider whether you satisfy those primary considerations that the court will give consideration to: the interests of the beneficiaries, whether there's a real risk of detriment to the estate, and of course the testator's wishes. And when lodging these applications, make sure that you evidence efforts to engage with the personal representatives in the first instance and resolve matters. And if those efforts have not proved to be of any use, then there is a real risk to the estate, to the administration of the estate, that justifies making of an order in the terms that you seek. That's about it from me. We've got a chat function and a Q&A function here, and I do see a couple of questions. Yes, okay then. So this is from Jenna Sukar. Sorry to put this in the chat by mistake. How do you determine whether someone has intermeddled with an estate for the purposes of the citation? Amy?
Well, I mean, I think you're talking generally, aren't you, about how do you determine in any event whether someone is, it's a more general question, isn't it, about what evidence do you have? I mean, you'll be able to speak as to the degree of evidence required for the citation process. But in any event, if you, very often the first way of ascertaining whether there has been an intermeddling is by usually by obtaining accounts or by those sorts of questions. And I don't know if you're using the citation process, whether there is any sort of additional aspect you can take into account, or
no. I think essentially the issue is, has the relevant party intermeddled with the estate? If you can use the citation process whether or not the person who would otherwise take a grant has intermeddled with the estate. The only difference is the options that are available to you in the process that that you go through. If there hasn't been any intermeddling with the estate, then so long as the person who is cited doesn't enter an appearance within the requisite 8 days, then they're essentially, as an operation of law, as I said, their rights to a grant ceases automatically. Whereas if they have intermeddled with the estate, then it will be necessary for your client then to make an application to the court for an order that someone else is appointed as a personal representative, as I said, either them or someone else who's noted in the summons. And so actually, whether or not there's been intermeddling doesn't in any way debar your client from the option of pursuing the citation process. It is a consideration to bear in mind when deciding how exactly one goes about pursuing that process. I hope that's of some help. So we've got one from Sally Patterson here. Hello, are you able to offer any advice regarding an appointment professional executor of a law firm that has then left the firm? Is there any way of removing them as an executor if they've joined another firm and are now wanting to be paid in their capacity as executor? Thank you.
There are immediate questions of conflict. I suppose they will depend, assuming that the new firm is a competitor or a similar nature, there may be questions of conflict there. And whether you, I don't know, it would depend on the facts really, because obviously there's a lot of detail in what Paul has said about the removal process. So it would be rather difficult to answer that definitively. But there certainly must be arguments, I think, aren't there, if depending on what covenants as well are in place, which might restrict their position as an executor of the old firm. That's something also to consider as well, which is perhaps not strictly a trusts process, but I don't know if you've got any thoughts on that one.
Well, yeah, exactly. Covenants and confidentiality and those sorts of, again, the thrust has to be, does the fact that this professional executor has moved to a new firm mean, in the circumstances, and of course every case is different, that there's a real risk that the administration of the estate is going to be detrimentally impacted upon it, and really, as I say, each case will have to be addressed on its merits. But as we sort of touched on, there are certainly reasons that one can think of where this sort of situation could give rise to a real risk of detriment to the administration of the estate. And if you can point directly to that, then yes, I would think that might well be something that would found an application, a successful application under section 50.
There's one from Rajinder Ray. What do you do if an administrator removes themselves from estate administration after receipt of letters of administration and then appoints another after estate accounts are prepared? Is that intermeddling? It certainly raises questions about that. You want to, again, I think there's a sort of vein of questions here, aren't there, about what amounts to intermeddling and how do you prove intermeddling, which can be difficult, because of course a lot of the thrust of our talks have been about being cautious about the approach you take and making sure that your application or your claim fits the criteria you need to really get what you want, essentially. And so there may be situations where an administrator's actions look questionable, but they don't necessarily amount to intermeddling.
What about circumstances where an executor has the grant but then wants to renounce because they have in the intervening time become errant in their duties? I'm not sure I quite understand the thrust of the question, because assuming that our client, whoever that might be, a beneficiary, would like for that personal representative to cease acting because they've been errant in their duties, then I can imagine that's a renunciation that we would support.
Yeah, it'd be very handy, very convenient, wouldn't it, for anyone who gets given the rather poisoned chalice of being a PR. They just decided they'd be a bit errant and then maybe get them to manage to get renounced. I mean, I'm sure it may be possible, but I suppose that there are questions about, you know, what has been the erroneous nature of their activities and how errant, and can they be persuaded? Because effectively somebody needs to hold that position, really. And so I think it's in theory that may be the case, but one needs rather more information, really, to see what's the best thing to do.
A question here from Richard Charles. Section 116 applications, can it be made to the court to pass over if you already have a citation in place before the Chancery? That's a good question. It's not one that I know the answer to. I'd have to look into that, but it's an interesting point, Richard. So what we'll do is we'll look into that and we'll certainly come back to you on that. Very good question. Thank you.
I'm not sure what you mean. So we've got Bhadresh Goyal, in terms of engaging with a difficult PR, what is the actual role of a judicial PR? I'm not quite sure what you mean by that. Do you mean a judicial trustee? Because a judicial trustee, if you mean that, they would they might take over, but they might step in and work in tandem or assist a PR. But one would like to think they wouldn't be difficult and they would do a better job. But I'm not sure if that's what you mean, actually.
If we are talking about a judicial trustee, and I think one thing that's to note is that they, when appointed, unless the court goes to what is, I understand, the unusual step of specifying the areas of the estate that the judicial trustee should deal with, they will be expected to deal with and assist with the administration of the whole estate. I mean, I think that's slightly tangential to the question, but probably worth noting.
Yeah.
Yes, I think. Yeah. Thanks, Pandresh.
Okay.
That's great. Okay.
Well, I think that covers everything. So thank you once again for making time to attend. And yes, as we said, the slides and a recording of this will be available on the 42 Bedford Row website, so you can look at that later. And of course, we have, I think, yes, there are email addresses. So obviously, any further questions or any particularly interesting points, please feel free to contact us. We'd love to hear from you.
Thank you.
Thank you.
Good evening. Bye-bye.